Contributory negligence essentially says that if you're at any percent at fault for your injuries as a result of any kind of collision, accident, things of that nature, that you can't recover. It is a complete bar for recovery, which is unlike most states, which actually have a balancing of comparative negligence to see what the defendant did versus what the plaintiff did. In North Carolina, regardless of what the defendant did, if your client is any percent at fault, there's no recovery.
Wow. So how do you deal with that?
You take a case on a case-by-case basis. I will tell you that one of the main areas where that comes into effect that I see quite frequently is in pedestrian cases. Because in North Carolina, in pedestrian cases, if you're not crossing in a crosswalk, if you're outside of the crosswalk, then that can be a complete bar to your client's case, regardless of what the defendant did. Now, there are some things that are in effect that actually help fight contributory negligence, but still, it's been my experience that once the jury hears that if you find the plaintiff at any percent at fault, they can't recover, that those exceptions to contributory negligence really don't apply. The jury really throws the law out the door.
So other than being really, really picky with the cases you take, what are some things you've learned to try to, get around, disprove your client's own potential 1% at faultness?
Well, what ends up happening is that you have to do a lot of investigation work on the front end. And that means that it's important that, number one, you get the case in early on so that if there are witnesses, you can go and talk with witnesses. It's important that you go and talk with law enforcement. Because law enforcement, unfortunately, they don't always get it right. They didn't talk with folks that were there at the scene. Sometimes there's video that helps. But then when you get that information in, one of the exceptions to contributory negligence is a rule called last clear chance. And so what that essentially says is that if the defendant had the last clear chance to avoid striking your client if they noticed that your client was in a position of peril, then the defendant must do that. And if not, that is an exception to contributory negligence.
Wow.
Well, the law has kind of evolved in that area, and so because it's evolved, the courts have really put a lot of restrictions on that. So when I said earlier that the exceptions really don't apply, so one of the things that's part of that rule is that in order for the defendant to have the last clear chance, they needed the opportunity to observe your client. Well, of course, defense attorneys know that, so when they come in, the first thing that they've already prepped their client on is that, no, I didn't have a chance to see your client. I never noticed that they were in a position of peril. I didn't see them until I was right up on them and the accident happened.
So then you got to get an expert, I guess, to try to disprove that had they been paying attention, they would have seen.
Absolutely.
Any other ways besides that last clear chance you guys can get around the contributory?
Well, then there's the issue of gross negligence. So
if you guys have really limited in North Carolina too.
Yes. So, gross negligence has really been kind of restricted in North Carolina. And so some of the things where we see that really apply as far as gross negligence were issues with speeding of the defendant. So if the driver was going in excess of the speed limit, when we're talking excess, we're talking, courts are really looking at 10 miles more over the speed limit. There's also, of course, drunk driving or the use of drugs while operating a vehicle and things of that nature that may be another cause of the collision that show that the defendant was grossly negligent. One of the things that we're really working on right now, trying to get some good law established on, is the use of cell phones.
Yeah.
As being a factor for applying gross negligence. Courts have been very reluctant to apply that because, they look at the old case law and they say, we're not really here to make new case law. If legislature wants it to be considered as being gross negligence, they'll write it into the statute. But we're really pushing to try and get some legislation done to have that in effect.
Well, the good thing, you have all those studies that show that using a phone while driving is equivalent of having a 0.10 blood alcohol equivalent of drunk driving. It's just getting the judge to do the right thing or getting the legislature to do the right thing.
That's right. And again, I think that because they're so used to how the law was before and old standards of law, a lot of judges are just reluctant, especially at the trial level, just reluctant to take that next step.
Yeah, so I guess you got to make a really good record then if you ever want to take one of these up.
That's right.
You have the right case.
And that's it. case selection. You've got to have the right case, because if you take it up and it's the wrong case, then you can make some really bad law that's going to affect a lot of plaintiffs.